for another reason, mute yourself. Secondly, I am Elliot Church. I am the chair of the International Law section of the State Bar of Michigan. This is a panel discussion entitled Trading in Music, Law, Business Practices, and Cross-Border Issues. This is part two. Part one happened last week, and part one was intended to be preparatory, a coverage of the law that's relevant, so you can understand the point of departure for today. So some of you will have some understanding of the law. If you feel you need to review, that session is recorded, and I will distribute a link to it after this meeting. So if there are references to the law that you don't understand, and we'll be addressing business industry practices and cross-border issues, this is intended to be the next step in that discussion. We are truly pleased to have with us an impressive set of panelists: Jeff Brabec, Todd Brabec, Dan Millington, Stan Soocher. And I will introduce Stan. Stan will also be moderating in addition to delivering content. So I will introduce Stan. I will make a couple announcements right now, and then we'll be on our way. And Stan will introduce Jeff, Todd, and Dan. Okay. Announcements, procedural matters, and one acknowledgement. First of all, beginning on April 7, we will have the first of two presentations on ADR, that is Alternative Dispute Resolution around the world. That first session is going to be ADR in Africa, and we'll have attorneys from Nigeria and Zimbabwe. Shortly after, we'll have a session on ADR in the Middle East, and you will be notified of the ability to register for that when registration's open. Regarding procedural notes, I will once again ask everyone to mute themselves. If you're signing on right now, please mute yourself so that we can maintain a suitable environment for this discussion.
So you
Secondly,
lose the of adding to that process, to that
I have 36 hours. He put me on this.
Yeah.
Once again, I'm going to ask everyone who's not on mute to mute yourself. Some people are not on mute, and I need you to mute yourself before we continue. Thank you. I will not be moderating the discussion, but I will interject questions. If you have questions, please put them in the chat. I will interject them at the right time and as soon as possible. I will also cue us as to time. And in particular, when we get close to the top of the hour, I'm going to announce that the meeting is coming to an end. At that time, panelists may drop off, participants may drop off, moderators and hosts may drop off, but anyone who wants to continue the discussion is welcome to do so. So this meeting will remain open, and I invite you to stay if you're enjoying the conversation, either as a panelist or a participant. With that, let me acknowledge Attorney Liz Storm. Liz Storm is an International Law Section Council member. Liz specializes in precisely the set of topics that we will cover today, and I want to acknowledge her because, number one, she came up with the idea for this. Number two, she assembled the impressive panel. And number three, it is probably as a result of her efforts that you who are here today are aware that we're having this. So Liz, thank you. With that, I'd like to introduce Stan Soocher. So Stan will be a panelist as well as moderator today. Stan, welcome. Stan is a professor at the University of Colorado, Denver campus. And I was looking at Stan's biography, and my conclusion is this. I think he's been interviewed by every major news organization. I think he's presented to bar associations and industry conferences in every major city in the U.S. And won numerous awards in the area of entertainment law and music. The thing that also stands out to me from his biography is that he was a professor of not only entertainment law, but also of music, and in fact, the chair of the music department at the University of Colorado. And what that suggests to me is this dual expertise. And it's people like that that I think are very valuable, especially when you're coming to an area of law that you have some subject matter expertise. So Stan is an expert. He's a musician, a drummer, and we're happy to have him. With that, Stan, I turn it over to you. Thank you.
Thank you very much, Elliot. Appreciate that, the introduction. And want to thank you and Liz and the State Bar of Michigan, particularly Liz and yourself, for putting this panel together. And and it's my pleasure to moderate the panel and to introduce our three great panelists who I'll be moderating for. And I'll introduce it in the order that they'll be speaking. First, Todd Brabec, former ASCAP, former Executive Vice President, American Society of Composers, Authors, and Publishers, and also he was Worldwide Director of Membership. He was at ASCAP for 37 years, where he was responsible for all membership operations, personnel, and offices, as well as the signing of many artists, including many of the major artists, songwriters, composers who signed with ASCAP. He and Jeff Brabec, who will be, of course, on our panel. You see them together on the screen there waving, are co-authors of one of the most referenced books in the music business on music publishing. It's named Music, Money, and Success, The Insider's Guide to Making Money in the Music Business, and it is incredibly currently in a rare position of being in its 8th edition. That's 8 editions. That's very rare in the book publishing industry, and certainly in the music industry. What, Todd, you were saying it's
8.
8. Yeah, I said 8. You're right. And also, Todd is an adjunct professor at University of Southern California. He teaches music licensing and music publishing, and he's a former governing committee member at the American Bar Association's Forum on the Entertainment and Sports Industry. Dan Millington is Senior Member Relationship Manager at PPL UK Limited, which deals with, and he'll explain too, the recording rights, so-called neighboring rights. And his main responsibility is working with artists and their representatives to ensure UK and international revenues from these, what I've just explained, and he'll go into detail on this, the neighboring rights, to make sure those revenues are maximized. Dan has been with PPL almost 12 years, working with the Membership Services Department as part of their senior management team. And then I've already mentioned Jeff Brabec. Jeff is currently Vice President of Business and Legal Affairs for BMG Rights Management, which is the 4th largest music publishing company in the world. Jeff specializes in evaluating, analyzing, projecting income, and negotiating music publishing catalog acquisitions, in addition to a variety of other agreements from songwriter to co-publishing, administration, Broadway musical agreements, and other contractual issues in music publishing. I mentioned he's a co-author with Todd of Music, Money, and Success in its 8th edition. Like Todd, he's been awarded the Deems Taylor Award for Excellence in Music Journalism, the Tech Star Award by the Entertainment Sports Law section of the Texas Bar. He's also an adjunct professor at USC Thornton School of Music, along with Todd, where he teaches music publishing and music licensing. And both, just one quick note, because you want to, there's a lot to say about all three panelists, but I know you want to hear from them on the domestic and international issues in trading and music. They're both also contributing editors to Entertainment Law and Finance. My pleasure to say that. I've been the longtime editor-in-chief of that publication, and they're really great, knowledgeable people. So Todd, Dan, and Jeff, welcome. And let's launch right into Todd starting us off.
Thanks, Dan. Hey, quickly, I'm going to give you a crash course in the PRO, Performing Rights Organizations area, both in the U.S. and outside the United States and foreign countries and stuff. And, this is a truncated version, but if you want, we've got very long chapters on all the subject matter we're going to discuss today in this. So I do recommend the book if you want to get into detail here. In the United States, as most people know, you've got 4 performing rights organizations: ASCAP, BMI, CSAC, and Global Music Rights, GMR. ASCAP and BMI are nonprofit organizations. Both CSAC and GMR are for-profit corporations and stuff. As most people know, these writers and publishers, songwriters, composers, and publishers join these organizations, who then negotiate license fees with the users of music. Could be TV stations, could be local radio stations, Spotify, Netflix, you name it. They collect the money and then distribute it back to writers and publishers 50-50 based on who has performances in any of those mediums. So that's basically the structure of these organizations. They do a lot more than that, but that's the basic structure of why they're in existence. Now, what the important thing to note is that as far as license fees goes, both ASCAP and BMI are under consent decrees with the government, the DOJ, oversees them to a certain extent in how they run their operations on it. And that really stems from 1941 cases, antitrust cases, for alleged violations of the antitrust laws, the Sherman Act, to be specific on it. Now, as part of these two decrees with ASCAP and BMI, rate courts were established in 1950 for ASCAP and 1994 for BMI, where actually, if either of those two organizations can't come to an agreement with what reasonable license fees should be for any given medium, network TV or streaming services, whomever, either party can go to court, federal district court in New York, Southern District, and there's an actual trial, and judges make the decisions as to what the fees should be for that particular media. And so it's a very important aspect of these decrees because, you can't just stop playing the music. There's always some kind of dispute resolution procedure for users or for BMI. In the case of CSAC, they're not under a consent decree at all. They do have, due to some settlements in the private antitrust litigation with the local TV industry and local radio industry, there are some settlements where they're obligated to have mandatory arbitration if they can't come to what reasonable fees are for the use of CSAC repertory or global music rights repertory in their areas. With global music rights, they're completely unregulated at the moment, so there is some litigation, antitrust litigation going on right now as to that particular procedure because there are really no dispute resolution procedures for users and GMR other than copyright infringement suits. So we'll see where that goes in the future. Just, the amount of money we're talking about here is very, very substantial. It's $3.1 billion is collected by these four organizations in the United States. And the breakdown, broadcast television, cable, about $800 million total. The online audiovisual and audiovisual streaming world, all types of online use is about $700 million. The $400 million comes in from general licensing, which is all the live concerts, universities, any type of music is used in bars, restaurants. And $450 million comes in from broadcast radio and satellite radio. So that's where the revenue comes in from. Another important aspect here in the foreign area, ASCAP and BMI and CSAC and GMR collect about $800 million that comes in from foreign performing rights organizations. Now, most of that is writer money because most publishers are collecting their money in the local territory as a member of its local society or through a sub-publisher. The important that's important for this discussion is because the U.S. repertory obviously is huge because if $800 billion is coming in from all these societies, that's an important aspect of the revenue that songwriters, composers, and publishers make in the United States. Now, the foreign revenue comes through based on reciprocal agreements with foreign collection societies, foreign performing rights organizations. I'll give you just three of them, just for PRS and for music in London is one of the largest. It's really for the UK and some of its territories. Collects about I think, $1.2 billion. SACEM in France, another major one, which covers all of France, is about $1.3 billion in revenue. SOCAN in Canada, about $320 million collections. APRA in Australia and New Zealand, about $363 million. A lot of that, a good portion of that money, comes to ASCAP, BMI, CSAC, and GMR because of the popularity of U.S. repertory, both in the radio area and the television area. And I use those terms meaning the audiovisual and audio streaming areas also, and including live performances. So again, they're done through reciprocal agreements between these societies, which are negotiated agreements. And they're very similar, but it's basically they collect for our works here and we collect for their works there. A good example is take the Beatles, Lennon and McCartney. Lennon's estate is a member of PRS. BMI collects for Lennon in the US, sends his money to PRS, who then distributes it. McCartney is a member of PRS in London. ASCAP controls his rights in the United States. Any Beatles performances for McCartney's share goes to PRS through ASCAP. So that's how these reciprocal agreements work. As far as licenses go, it's an important aspect of this whole thing about what type of agreements people sign. You've got four basic types. One's the blanket agreement, where it allows unlimited access for a user to everything in a PRO's repertory. This is the license that you use throughout the entire world by most PROs out there. You've got additional licenses as a carve-out blanket licenses, which really is a blanket license where you reduce it by the number of direct licenses that the user has entered into. I'll get into that in a second. Per program license involves only programs that broadcast ASCAP or BMI music, but that's not directly licensed. Through to the audience license is very important. I'll read it. The fee takes into account the value of all performances made pursuant to the license, including all further transmissions by users with an economic relationship to the license. Very simply put, think of network TV, ABC Network, all of its affiliates. When ABC performs something, all of its affiliated stations are under that license. So that's a through to the audience license. There are also direct and source licenses, which are very important because writers and publishers, even though they're members of ASCAP, BMI, and CSAC, can also license outside of those organizations. It's called a direct license if they're doing a license for music with a broadcaster, or a source license if they're doing a license with a particular program producer. So that's an availability. Even though you're members of these organizations, if they're non-exclusive agreements, so you can license outside of them if you wanted to. That's pretty much on as far as the ASCAP, BMI, and CSAC go and stuff. I tell you, they're very important organizations, and the decrees, the Justice Department decrees with the ASCAP and BMI, they were under review for the last 2 years. The final decision came out about a month ago, and they're making no changes in the decrees whatsoever. So it was everybody wanted to see changes, but nothing happened. Let me quickly go to another organization, exceptionally important, Sound Exchange. Now, just so you know, when somebody refers to a statutory license in the U.S., all that means is that if you're using intellectual property, anybody who uses intellectual property, they must obtain permission. And they can either do that directly from the rights owner, whoever the copyright owner is, through a private contract or a license, or indirectly from the federal government through a process codified in the U.S. law that grants specific rights to those who meet statutory requirements. So the federal law dictates the conditions and price of this type of license and stuff. Now, there's no ability to withhold your compositions or your music when you're under a compulsory license. Now, these compulsory licenses are administered by entities that design to really, for the specific task and stuff like that, to actually handle the royalties for these specific types of statutory licenses. In the U.S., in 1995 and 1998, the laws were passed, the Digital Performance Rights Sound Recording Act and the Digital Millennium Copyright Act. They created a limited public performance right in sound recordings. It's similar to the ASCAP and BMI right, but it's limited to digital only, and it applies for non-interactive streaming services. So think of Spotify and those, think of Pandora and those type of audio streaming services now. Now it's sold to that designated by the Library of Congress to actually collect these royalties and distribute them. And last year they collected about $963 million and distributed $908 million of that. So it's a significant amount of money. And it goes primarily to 50% to the sound recording owners, which is normally the label, the record label, 45% to the featured musician, 2.5% to non-featured musicians, and 2.5% of that fee to non-featured vocalists. Both of those go through the AFM and through SAG-AFTRA. Now, the rates in this area are decided by the Copyright Royalty Board. Current rates for commercial subscription services run through, the last deal was 2016 to 2020. Unfortunately, a new CRB hearing was delayed due to the government shutdown. That's upcoming shortly. SiriusXM pays 15.5% of their gross revenue to Sound Exchange. That is good through 2027. Music Choice, which is the cable channels on the end of the cable TV, the music audio channels. They pay 7.5% of their gross revenue. That's good through 2022 also, but it's under appeal, so those rates may change for Music Choice. Just for on-demand services, the Spotify's, where the listener actually picks what they want to hear, that has nothing to do with the compulsory license or sound exchange. They are all obligated to negotiate directly with the labels for whatever the fee should be. So that's a whole separate entity when you're dealing with the interactive services.
Well, go ahead. We want to just get from Dan when you mentioned sound exchange, Todd, there, Dan will be addressing the relationship of the British PPL to sound exchange on the sound recording side.
Which is important. That comes next because one of the things that sound exchange does have, they've got agreement with over 45, they call them collective management organizations throughout the world, which PPL is one, which really they have reciprocal agreements where the money flows back and forth. But with the U.S., as Dan will get into, it's very limited right. It doesn't apply to terrestrial broadcast radio at all, only limited to the non-interactive streaming services. But you do have to be join Sound Exchange to actually collect this money from the foreign societies through these reciprocal agreements. So that's a crash course in both the PROs and
Great, thank you.
If I may interject just one comment to the audience. If anyone has a question for the panelists, please put it into the chat and we'll make sure it gets in front of the panelists. Thank you. And with that, I want to introduce one question, which is, you mentioned that some of those licensing organizations are profit and some are nonprofit. Is there any difference between how they operate or any other difference that's material?
Yeah, well, the main difference is that with ASCAP and BMI, they pay operating costs, which is probably about 11% of their whole operation. And all the rest of it goes out 50-50 to writers and publishers. With CSAC and GMR, they are for-profit corporations. They do not publish their revenue figures nor distribution figures. So there is a profit aspect to I think the Blackstone is one that owns CSAC right now. It's Irving Azoff and partners and who own GMR. So, however they distribute their money, when the distributions go out, they go 50-50 to writers and publishers. What the profit aspect is not known.
Thank you. Thank you so much, Todd. Lots of great information, very practical, and puts it in perspective. Dan, from the UK side.
Hi.
Yeah.
Well, yeah. Hi. Thanks for having me. So I'll crack on. So I'm aware of time. So I guess following on from Todd's, there, I guess what I'm going to look to do really is just talk a little bit about PPL and public performance licensing in the UK, and then kind of look at some of the more interesting things. Not that isn't interesting, but look at some of the interesting things that's happening further afield. So a little bit about PPL. We've actually been around since 1934, and we came around when what became Decca and DMI, they actually sued a coffee shop in Bristol for playing their records. And the business for the coffee shop was booming, and the labels basically saw that it was their music that sort of played a big part in that, and they thought that they should receive a share of the profits. And they actually won that case, and the record labels then set up PPL. And we were set up to administer that licensing activity. We operate, a little bit like Todd was just talking about, we operate on a not-for-profit basis as well, and always have done. And if you kind of fast forward, and it's a bit of a whistle-stop tour, but if you fast forward about to the 60s, we have what we call the Rome Convention, which essentially enshrined into law that any public exploitation of the sound recording should be protected and licensed. It's actually an international treaty. Many countries signed up to it, with the notable exception, or one of the notable exceptions, of the US that didn't sign up to it. And I'll kind of come on to that a little bit later. Now, for reference, when I'm talking about public performance licensing, I'm referring to kind of any place or business that plays or publicly plays recorded music. So we're here to protect the master sound recording itself. And that can be a restaurant, shop, office, pub, literally anywhere, as long as there's more than one person in that in that venue, then they need a license to play that music. Alongside that, we also license traditional broadcasts, so radio, TV, and that's both digital and analog formats, as well as more kind of contemporary formats, including online radio and even some of the kind of on-demand services. Primarily, we operate on a blanket license basis, so a broadcaster or a business wants to play music, they pay a fee, and it means they can pretty much play whatever they want. So TV stations that are creating a television program don't have to seek clearance for specific tracks. If it's on PPL's database, then they basically have access to use those recordings. Probably also worth noting, as Stan mentioned earlier, when we're talking about these rights, we tend to refer to this licensing activity and the rights around it as neighbouring rights. It's an increasingly important income stream. In the UK, it generates over £200 million per year. So it actually wasn't until the mid-90s, however, that performers gained a legal right to any revenue that was generated from this licensing activity. And it was a thing called the Performances and Phonograms Treaty, which was in 1996, that gave the performer that legal right to what we refer to as equitable remuneration. Prior to this, we did actually pay performers, but it was all ex gratia. There was no requirement for any, and this is the same pretty much anywhere, there's no requirement really for any reporting or even justification on what we were paying them. It was more of a handshake agreement. What that meant, what the treaty really meant, was that societies or CMOs had to be fully transparent and accountable for the revenue that was being paid through to the performer. And actually now that revenue is pretty much split 50-50 between the performer and the record label. And at that time, PPL actually became a joint society, much like Sound Exchanges. We work for both the performers and the record labels. We also implemented a performer board as well, because we felt that it was important for the performers to have representation at that level. A really, really important thing with this right, especially outside of the US, is that it's a legal right, and it's one that is non-transferable, which means I can't sign it away in contract. I can't assign it to another party. I basically can't give away my right to this particular income stream. So that's very different to many of the rights that we talk about, including the writer's share and all of that. The only time that you can do that is at the point that the performer passes away. At that point, it becomes transferable. The right is actually then seen as a property right. And for anyone on here who's dealing with any artist at all, I would implore you to put the term neighbouring rights into their will if you can, because it makes transferring future revenue to beneficiaries so much simpler when that particular income stream is specifically referenced. Otherwise, it can be quite a long process. So that's sort of PPL from a UK perspective. Now, when a member joins PPL, they can sign an international agreement with us, which enables us to go around the world, collect this income on their behalf. And as Todd mentions, that's done via the reciprocal agreements that we have in place with equivalent CMOs around the world. It's over 40 territories that PPL has these agreements in place with. Not every territory is the same. So it would appear as throughout my years at PPL, that you learn that each territory kind of has different interpretations of the treaties that are in place. So they all license things slightly differently. So an example that I often use is Brazil. So whilst most territories don't have any kind of public performance rights for the use of a piece of music in a film, and that's because that piece of music is often put in the film as part of a direct license agreement. In Brazil, once that film's actually played in the cinema, it actually then falls under their public performance licensing for the venue. So by virtue of the fact that there's music kind of can be heard in the venue, it then that piece of music generates income. Doesn't really happen anywhere else, but in Brazil it does. So we're able to make sure that revenue is collected, even though that's not how the licensing works in the UK. You see all kinds of other things. So in France, for example, there's a levy that's in place on blank media. So it's it's called private copies, so kind of goes back to the blank media days, and the revenue basically that's generated from that levy goes to the local collecting society, and it's then distributed. Again, we don't have that in the UK, and many of the territories don't have that same kind of licensing, but it all falls underneath this form of license, or how they're all different, I guess, around the world. So I'll come back onto the Rome Convention, because this is where it gets quite interesting for me personally. I've probably been talking about this for nearly 12 years at PPL. The fact that the US didn't sign the Rome Convention has basically led to qualification issues in a world where the majority of performers do have a legal right to earn income when their music is exploited in broadcast and public performance. And what that means is that many of these US artists just simply don't qualify. So if the recording is being played on radio in the UK, for example, it's a US artist that lives in the US, records in the US, but has a really big hit in the UK. By virtue of the fact that they don't qualify, that performer actually doesn't have any rights to revenue that's generated on that recording. And in fact, as it's deemed non-qualifying, there's technically no performer share that's generated on that recording, and all of the revenue will go to the record label. For example, let's say Madonna has a huge hit that she releases today, shoots to number one in the airplay charts in the UK. She actually won't generate much, if any, revenue from the UK at all. There are some exceptions though, and that's where satellite and internet radio come into it, which I'll talk to you about in a second. There are ways around this though. Some of these are easier than others. So one is having dual citizenship, which isn't easy. But if you happen to have a citizenship in a qualifying territory, so a Rome Convention territory, so let's say Canada or the UK or most of the rest of the world, that would be seen as a way that you could generate this, or you'd have an entitlement to this income. Residency is also an example as well. So if I happen to live in the UK, but I record all of my stuff in the US, I'm a US artist, but because I have residency in a qualifying territory, I'll also get paid. The other one, which I tend to advise most of my US clients, is go and record somewhere else. So your part on that recording, if it's done in say Canada or Mexico, means that then your performance will qualify, and that can have a really huge impact on the revenue that you would generate. So again, going back to Madonna, she used to live in the UK. She lived in London for, I think it was about 10 years. And during that time, everything she did, even if she did it in the US, would actually qualify, and she would get paid for it. As soon as she left the UK and went back to the US, then her residency finished. So any future work that she did in the US no longer qualifies. So a few years back, we did change our policy, and we actually we now reciprocate licensing with Sound Exchange. So what that means is that we now do pay US artists for revenue generated from satellite and internet radio. Unfortunately, that's a tiny part of the revenue that gets generated in the UK. Unlike the US, where satellite radio is huge, there's huge coverage, huge listenership. You buy a new car, and I believe it probably comes with a subscription to Sirius XM or something as part of the purchase of the car. In the UK, just isn't a thing. It exists, but the listenership is minute, so it just doesn't generate much income at all, unfortunately.
Dan, would you, while we've got you for another minute or two, I hope, I know you'll be on the panel for the questions as well and answers. The impact of Brexit, which took effect at the beginning of this year, beginning of 2021, of the UK leaving the European Union. What do you see from your perspective as impact on what you do from the Brexit?
So it's a really good question, and I'll try not to look too upset when I start talking about Brexit. The reality is Brexit is it's still, even though we agreed to do Brexit 4 or 5 years ago, it's still a bit of an unknown in terms of the long-term impact from a neighbouring rights and reciprocal agreements perspective. So one real tangible thing that's happened recently is talking about performer qualification. So in Ireland, the European courts just passed a ruling to say that US artists should qualify, regardless of where they perform, regardless of where, anything. They should have the same rights that all other artists do. And that will basically be implemented across Europe, as is the case when a ruling gets passed in Europe. Now, because we are not part of Europe anymore, and the UK is a huge generator of income when it comes to neighbouring rights, we're not going to immediately have that put into place in the UK. So, that's probably one of the most immediate impacts that we've seen. It's like, well, how will that, change how we do things in the UK? How will we look to implement these rights for US artists so that they will qualify the same as they will now in Europe? And ironically, it will probably end up being part of a US-UK trade deal. And it's something that will probably end up on the table as part of that deal outside of our EU agreement. So yeah, we're hopeful that Brexit doesn't have a long-term kind of financial impact. We're just yet to see that. But at the moment, our own Prime Minister probably only saw the actual, he's probably not finished reading it actually, but only saw the terms of the agreement a few days before we were supposed to pass it. So it's all still very fresh at the moment, I would say, if that answers your question.
Yeah. Oh, yeah, very much. And so you're seeing it as more of a transition at this point than an end of something.
Sure.
Which is good news. Which is good news for the music industry. So Jeff Brabec, let's turn to you to discuss a variety of issues as well. Just noting that Jeff is on the board of the new music mechanical licensing collective, which was set up in the U.S. under the Music Modernization Act. So he'll start by explaining that, and then he'll move into the international rights arena as well.
Great, Stan. Thank you. I'm going to switch it around a little bit. I'm going to talk about the MLC and the interactive streaming rates in the second portion of my little segment, because there are a lot of moving parts there, to put it mildly right now. I do want to touch, first of all, on follow up some things that Tim Matson said in the last conference, who did very well on both television primarily, because it definitely has a relationship to foreign countries and the interrelationship between the U.S. and how we deal with television and the business aspects. In television, basically you've got two types of shows, and I'm generalizing right now. You've got your dramatic show, such as a Westworld, and then you've got the music and dance centric shows, the Voices, So You Think You Can Dance, The Masked Singer, one of my favorite shows. Yes, of course. So you have two different types of licensing, and they're different in some respects with respect to the U.S. versus foreign markets. I'll give you a quick example. As far as television, basically when a request comes into us for licensing a composition, basically we get a synopsis of the series, the identity of the composition, we get a scene description, extremely important. They detail the use of the composition, whether it's a visual vocal, background instrumental, etc. Duration of the use, 30 seconds, minute and a half, full usage, etc. The territory. Normally in dramatic shows, it is always the world or a universe. Most producers are now using universe as opposed to the world, because these shows will be around for a long time as far as territory. And then term. In a dramatic show, it's always life of copyright. And basically, I'll give you a quick example. In Westworld, which is one of my favorite series, there was one episode that had pre-existing songs and master recordings: Night Clubbing by Iggy Pop, Space Oddity by the Classic Rock String Quartet, Emerged by Fisher Spooner, all in one episode. There's master rights, master recording rights, and there's music publishing, song rights, etc. All of these dramatic shows are normally licensed under what is called an all media excluding theatrical license. And all media is very broad. Basically, what the producer can do is distribute the episodes to any and all media now known or hereafter devised. The only thing they can't do is put it into a motion picture theater, because that's excluding theatrical. Now, that may change a little bit, because there were 2 Game of Thrones episodes put into theaters a couple of years ago. So that's a slight variation on the license. In effect, there's one fee, one-time sync fee, to put the song or master recording into the dramatic series. That includes all media, including home video, downloading to your phone or your digital device, etc. So it's a one-time fee, no future royalties other than your back-end performance rights royalties when the episode is actually performed in foreign countries or in the United States. The interesting thing about the music and dance-centric shows, and this has a little variation of the theme, because these shows are fairly topical, and really relate to the United States or U.S. and Canada only. For example, I'll give you The Voice. The Voice, I believe, started in the Netherlands. There's a Voice show almost in every major country of the world. Who in France wants to watch the U.S. version of The Voice? They'll watch their own version, etc. So the shows are licensed differently. Instead of the dramatic show with the worldwide life of copyright license, these music and dance-centric shows are basically short-term, anywhere from 1 to 2 years, very limited territory, U.S. and Canada in most cases. The media is all television, including streaming. Now, the interesting thing about these licenses is that because they're short-term and limited territory, certain producers, feel that certain episodes might want to be shown in foreign countries. So you've got a number of options in all these territories. One option is to extend the term from the U.S. and Canada to the world. There's additional monies being paid for that. And also they can extend the term from 1 to 2 years to life of copyright with additional fees. And there are options galore in all these music and dance-centric shows to expand the rights of the producer if, in fact, they feel that they need more extended rights. So the last word on that is that the interesting thing about dramatic TV versus the music and dance-centric shows, dramatic TV, purely negotiable. Obviously no statutory rates whatsoever. In the music and dance situations, all the songs are being paid on the most favored nations basis, which means every song is paid the same depending on its timing and type of use in the show. And so your only decision was when one of these requests comes in, which have, as I said, many options, is to say yes or no, because all the fees are stated in the request, and there's no negotiation whatsoever. I'm going to move on to, as I said, an area where there's a lot of moving parts right now, but it is one of the main sources of income in the future for writers and music publishers. It has to do with interactive streaming royalties. In an interactive stream, let's take a Spotify or Amazon, et cetera, or Apple, where the listener is able to choose what he or she wants to hear, the specific master recording, not just a genre of music, like I'd like to listen to reggae, but this is where I want, a specific artist, with a specific song. So that's interactive streaming. The Copyright Royalty Board, which is part of the Copyright Office, meets every 5 years to determine statutory rates for mechanical income. Now, in a interactive stream, there are two rights. One is the performance right, which is handled by ASCAP, BMI, CSAC, and GMR in the United States. The other is a mechanical reproduction right, which relates to downloads. It also relates to CDs and vinyl, but that's physical product. And primarily it relates to this interactive streaming situation, which is becoming more and more popular in the United States. As I said, the Copyright Royalty Board meets every 5 years. It's a negotiation, it's a trial. It lasts for about a 2-year period. The digital companies are part of it. The music publishers associations are part of it. The songwriter associations are part of this discussion. And in the past, all the parties have agreed to a resolution, and the Copyright Royalty Board has just stamped their approval. This most recent one, which was for the period 2018 to 2022, that 5-year period, the parties could not come to an agreement, so the Copyright Royalty Board actually determined what the fees were. Now, the fees are very interesting. The publishers and songwriters, we wanted just a flat rate per stream. Why get into the complexities of the prior formula that was in effect from 2013 to 2017? But the copy royalty judges didn't go that direction. They made a somewhat, we thought, simpler formula, but still somewhat complicated. And it was a very good decision for writers and music publishers. In fact, the rates in 2017 were, I'm being simplistic right now, 10.5% of the digital services revenue. Under the new rates going from 2018 to 2022, the rates were raised from 11.4% to 15.1% in 2022. That was about a 44% increase in these interactive streaming rates. Now, the formula is still somewhat complex, and I'll just be very straightforward with this. There were two line items, basically. The first line item is the percentage of the digital services revenue. The second line item is what they call the total content cost, or TCC, which is the amount of money that the digital services pay to the record companies to perform the master recordings. As Todd said, purely negotiable. The digital services have to deal with the labels to determine the fees for performances. Basically, what happens, and I'm going to use the rates for 2020 because you'll know why in a second. You had the two line items of 13.3% of a digital services revenue. The second line item was the TCC, 24.1%. You would take the greater of those two figures, and that would be your final percentage. Then what you would do is deduct the monies that were paid to the performance rights societies, the ASCAP and BMIs, and whatever was left over, that would be the royalty pool for these mechanical income. I'll just give you a quick example. This is a confidential cover royalty sheet from Pandora. It's got a number of line items from A to X. There are multiplications, there are additions, there are deletions, there are reductions, etc., on all various line items. That's how complicated the formula is to get to the final result. Very, very quickly, Spotify, I'll give you a quick example. 13.3%, let's say the amount of the service revenue was $5 million. The other aspect was 24.10%, the total cost content. That was what the Spotify paid to the record companies. Let's say that was $4 million. So $5 million is the royalty pool because that was the greater of. Then you deduct the performance royalties. Let's say that was $2,600,000. What you'd be left over with is $2.4 million, and that would be shared by all the songs in a particular service. To give you an exact rate, I'll give you a rate in 2020 on Pandora, one of these months. A rate per play was 0.000653. That was mechanical royalty for one performance on a digital service for a particular month.
So,
you can.
Jeff, I'm sorry. I was going to say for a time basis, could you just spend a couple of minutes explaining what the mechanical licensing collective is and how it interacts with foreign societies?
And my last comment, all the rates I just mentioned are under appeal because four of the digital services appealed to the district court in Washington, D.C., and so it was remanded back to the Copyright Royalty Board for further proceedings. Now, the Mechanical Licensing Collective is an entity which was created by the Music Modernization Act. It's a nonprofit organization. Basically, and I'm on the board of the MLC. Basically, it was designed to manage blanket mechanical licenses, which would give the digital services the right under a blanket license to perform any and all musical compositions that were performed in the United States under a blanket license. The MLC, which I'm part of, our role is to collect the royalties from the digital services and then to pay the correct copyright owners. Obviously, our role is to identify all the compositions being performed via the usage reports that the MLC or that the digital services provide us. The interesting thing about who is a member of the MLC, and this is very important, there are three categories pretty much. And it's the parties who actually own the mechanical rights, who can license the mechanical rights. One is our music publishers in the United States, because most of their agreements with their songwriters allow them to negotiate and collect for mechanical royalties. The other category is self-administered songwriters who own their own publishing. They own their mechanical rights, so they will be members of the Mechanical Rights Society. So those are two aspects. The third aspect, which is very important, is the foreign collection management organizations, those societies throughout the world who have the rights to license the mechanical royalties on behalf of their constituents, their writers and music publishers in the various foreign countries. Take SACEM in France or GEMA in Germany, etc. They will also be members of the Mechanical Rights or the Mechanical Licensing Collective, and they will receive the royalties that are paid by the digital services to the MLC, and then the MLC will be distributing royalties to all the various mechanical rights societies throughout the world. So that's the reciprocal type of situation. Now, this is a U.S. right only. We do not deal with foreign performances, Mechanical License Collective. All we deal with are the U.S. Digital services. But there is that relationship and value to foreign writers and music publishers and their respective collection societies by being members of the MLC. The last thing I'm going to say is that the site is themlc.com. There is an awful lot of information on there. We just received $424 million in unmatched royalties that the digital service companies were holding for many years. Our role is to identify the unmatched royalties and identify the correct copyright owners and pay that money out. But there's, as I said, a lot of information on the MLC.com website. But you have to become a member to receive these royalties. There's absolutely no fee. The organization is paid for by the digital service companies. They're doing that because there was a waiver of liability, so that's the value to them. And it's just a great organization, and we'll be collecting an awful lot of money and identifying the correct writers and publishers.
Thank you very much. Thank you, Jeff. Great. Just before we're going to go into the Q&A, but I'd just like to spend a couple of minutes addressing a very controversial issue, and this is the interaction of the right of authors under the U.S. Copyright Act to, at a certain point in time, to recapture rights in copyright assignments that these authors have made. How does that interact with international law, contract law in particular? We don't have a lot of U.S. case law on that. There was one that came out of England, the UK, dealing with the songwriting agreements of the band Duran Duran, who signed agreements with what's now an affiliated company of Sony Music Publishing, which granted Sony the worldwide rights to the copyrights in the songs for the life of the copyrights. Then Duran Duran in the US nevertheless moved under 17 USC section 203A for copyrights assignments that can be recaptured by the authors after 35 years. Filed notices, termination notices in the US, and they got sued by Sony's subsidiary Gloucester Place Music in the UK. And the UK trial court ruled that Duran Duran breached their UK agreement, giving Gloucester Music the worldwide rights in their songs. So that's really, and that was settled, never went up on appeal. But I do want to mention, we have had a couple of US court rulings, one out of the Second Circuit with Ennio Morricone, who did a lot of the Italian composer of the Italian spaghetti westerns. And he faced the same issue, filed his U.S. copyright termination notices under Section 203A. And then he filed for a declaratory action in the U.S. court to say that Italian law was not, where he's based, was not unfavorable to him. His contracts are signed onto Italian law. And the Second Circuit recognized that Italian law did not preempt, in other words, what Morricone did in Italy under their law. He was still the author of his songs of his works that were in the movies, his scores. And so he was able to go ahead with his termination notice in the US. last point is actually in the Copyright Act. There's a provision that allows for it. It came up in a recent case. I won't go into the case, but I will tell you it's Tom Clancy versus Jack Ryan Enterprises Limited from the U.S. District Court, District of Maryland, which cited a provision, Section 203B5, which states that the, quote, termination of a grant under this section affects only those rights covered by the grants that arise under U.S. copyright law and in no way affects rights arising under foreign laws, unquote. What that's saying, basically, if we look at it from the reverse, that international contracts that are signed for assigning copyrights doesn't eliminate the Section 203A right to recapture the U.S. portion of those authors' copyrights. Well, there we are. So that's our presentation, and guess we're now ready for the Q&A session.
Hey, Stan, may I interject a question from the audience? And so, the first question is, can someone speak to how sync rights work on international uses of material? And as a follow-up, are sync rights still required?
Well, I can definitely talk about that. And I'm talking about U.S. productions, first of all. I'm not talking about productions that are produced overseas. But if in fact, under U.S. law, if in fact you have a musical composition incorporated into an audiovisual work, you are definitely, you definitely need a synchronization license. And that synchronization license can be not just for the United States, but, we are worldwide. So you do need a sync license. There are a couple exceptions to that as far as PBS programs, but for general, normal, television commercial programs, you definitely need a synchronization right. If in fact you're putting music into an audiovisual product, and as opposed to something just live streamed.
Thank you. And a second question. This one is directed to Dan Millington specifically regarding PPL. Can you review the allocations of performers who are sharing the artist's share of neighboring rights royalties when there are two artists or performers on one song, one in the US and one in the UK, including when the artist or featured artists are deciding to share the royalties equally, and when they have one artist earn more, another less? What if the performer's in Canada? So there's some variations on this, but sharing, I think, is the essence of the question, Dan.
Yeah, so we essentially of the performer share that exists on the recording, so of the revenue generated, half of that, as I mentioned earlier, will go to the performers. So any qualifying performers that are on that recording will get their share. That's and it isn't we don't do any kind of share agreements per se. So you wouldn't come to as much like on the writing side where you say, oh, I allocate 15 points to here and so many points over here. It doesn't work like that on our side. The amount that you get paid, the percentage is based purely on your contribution on that recording. So are you a main artist, or you're a featuring artist, or are you a session player? So if you've got a whole bunch of qualifying contracted artists on that recording, they'll all get paid the share that they should get paid. If there's a non-qualifying performer on there, the US, it will only be that portion that's seen as non-qualifying, which would then go to the record label. We don't have any kind of real provision for the performers to come to us and say, actually, we want to share our qualifying part with this other entity, this performer who isn't qualifying. We don't really facilitate that. So at the moment, until the rules change around qualification, it's kind of a bit hard and fast.
Thank you, Dan. And another question, this is for anyone on the panel, but here is the question. Do foreign live recordings work for neighboring rights for US artists? And what is the date of commencement of that right? And what is the duration of that right? And is it for that recording only? So I think it's related to the scope of neighboring rights for US artists. Who would like to take that?
Well, I guess what I would say to that is that, and if I understand the question correctly, so we're saying here that a sound recording has been generated from a live performance, if that's how I'm interpreting the question, it's treated in exactly the same way as any other recording. So as soon as that performance is committed to record, and then it will then follow exactly the same the same rules and laws that exist around the traditional kind of record, I guess, that's come from the studio.
Thank you, Dan. So I want to observe that we are at the top of the hour. What that means is people may need to drop off. And if you do, feel free to listen to the rest of this via recording at your convenience. A link will be distributed, as well as a link to the past presentation on March 3rd. Before folks drop off, I want to briefly thank our 4 panelists, Jeff Brabec, Todd Brabec, Dan Millington, and Stan Soocher. And Stan, thank you also for moderating this discussion. With that, those of you who need to go, feel free. And those of you who want to stay, let's continue the discussion. And so the next question is a practical one. If so, from an international law, an international trade attorney's standpoint, a practicing attorney standpoint, let's say I'm an attorney in Michigan, and let's say I represent a company that produces games, software, so online games, and music is incorporated. Let's say the music varies from time to time, and so the repertoire is, let's say, large and variable, and we want to sell the game internationally. What are the steps that the attorney for that company needs to take to ensure that the game and the owner of the game is properly licensed? Do they need to go to the PROs? Do they need to go to all the PROs? Are there brokers, so to speak? What is the practice?
Try that question again a little simpler. If I'm understanding it, if you're dealing with a video game that's distributed throughout the world, is that under that heading? Right.
So one that incorporates music. And so the expectation is that there would be a need to license that. And you've spoken about the PROs, and they have large repertoires, all of them. How does an attorney or a company go about ensuring compliance with the applicable rights when you're selling a game that incorporates music and you're selling it internationally?
Yeah,
and I pose that.
No, understood. Okay. Well, if you're dealing in the video game area, I mean, you're dealing with either songs or musical compositions or scores and stuff. And with both aspects, with songs, as Jeff mentioned before, there's synchronization licenses with a grant by the copyright owner to the game developer or game publisher, whichever one they're dealing with, that gives unlimited worldwide rights to distribute that game, for that sync license. It's a one-time fee, or with music-centric games, you can actually get different type of royalty percentages and per unit royalties and stuff. But most games are a one-time fee. As far as the scores go, which is most of the music in many of these games, there's scoring agreements that look very similar to a typical Hollywood scoring agreement, where the grant of rights is completely unlimited, worldwide territory and stuff. So there's never a problem with the distribution of that game or performance of the game. As the performing rights go, in the United States, the games really aren't licensed by ASCAP, BMI, CSAC, or GMR, because it's mainly for home use. Unless a game becomes a television program or a feature film and stuff like that, then it could be licensed, at least in the broadcast area. There are different rules outside in foreign countries for that, where the foreign performing rights societies, I do believe, have some kind of right that's involved for when games are exploited over there, but not when they're sold at all. The selling is all covered in the U.S. sync license and the scoring agreement.
Yeah, it's also interesting, and going back a bit, in the motion picture area, when the U.S. producers were demanding that total buyouts for home video and then personal video. There were worldwide buyouts, and there were a number of societies throughout the world, mechanical rights societies, which objected to such worldwide licenses because it really was contrary to the rules and regulations of their particular territories. So there was a lot of negotiations going on there. But so there are conflicts on occasion that you really have to be careful of, and that issue was unresolved. But it got very heated for a while.
Thank you for addressing that. I want to point out before we go too far is that that the book that folks are referring to here a couple times is the Music, Money, and Success book by Todd and Jeff Brabec. I also want to point out that Stan Soocher is the author of a couple books. And if you look at his biography, you'll see what they are, but they have humorous titles. And it piqued my interest, and I imagine they would pique everyone's interest. So I invite you to look at Stan Soocher's biography as well, and check out the books that he has written. As a next question.
I do want to recommend Stan's books because they're really, they're very, very comprehensive, I must say.
And just to quickly note, one is Baby You're a Rich Man, Suing the Beatles for Fun and Profit. You mentioned it's a humorous title, but it's a legal history of the Beatles' legal issues, lawsuits, and a deep dive into archival material that to show cautionary tales that apply today as well.
Yeah, how apropos. So the references to your book, Todd and Jeff, are coming by way of some of the audience comments here. So there's been a lot of support for that as well. So thank you, gentlemen, for contributing to the educational literature about the industry.
I appreciate it. Oh, and Elliot, this is the large print edition of our book in the background.
For us old people.
I see. So this question goes to reciprocal rights. I think, Dan, you were describing how the U.S. is not a signatory to the Rome Convention. And it raises the question, how do U.S. artists work around that? It doesn't seem like they'd want to give up all foreign revenue. Do they cut private deals with the recording studio who gets 100% of the revenue? Or are there other conventional ways for U.S. artists to recoup some of what they would otherwise be entitled to? And then as a follow-up, why isn't the U.S. a signatory? And I guess I'll address that to Stan, maybe. Why? It seems like a disadvantage for U.S. artists.
Indeed, yeah. So I guess the first part of that is that there are certainly cases, and I've worked with artists where they've managed as part of their recording contract to convince a label to actually pass on a percentage of the neighbouring rights revenue that's generated from those sound recordings, where they basically otherwise don't qualify. More commonly, though, what we've seen in recent years are performers working to make themselves qualify, and most often that's done by virtue of where they actually record their parts on those particular tracks. So they'll typically, go and many artists record while they're on tour these days, so they typically find themselves in a qualifying territory anyway. So that would mean that their performance will qualify. I guess in terms of the Rome Convention itself, and Todd and Jeff might be able to give me a bit more on this, but from my understanding, kind of when this was around in terms of the conversations around it, I think it was kind of deemed that, because what it would mean effectively is that traditional kind of US radio stations would have to then suddenly start paying a license. And I think it was the view at the time that if your track was being played on a radio station in the US, as the artist and the record label, you should see that as promotion. And therefore there should be no need for any kind of license fee and therefore royalties generated from that to be in place, because you're getting the recognition from the radio station, which will ultimately turn into sales. So I think that was a big driver as to why the US didn't necessarily sign the Rome Convention back then. But I don't know if there's more nuances to that.
Yeah, and that's true, Dan, because the lobbying power of the broadcasters was so much more beyond what the music industry had and was able to,
Sure.
to garner. So this has been an ongoing controversial issue in terms of public performance royalties for now, not in the digital realm because sound recordings get that under US law, but with so-called terrestrial radio stations. And we're in the digital music age and digital channels, but still that controversy is there where sound recording owners, they want public performance rights when their songs are played on terrestrial radio. So yet again, legislation has been introduced into Congress to try to get this through. It hasn't gotten through yet. And that is, and you talked about it, Dan, earlier on the panel, that that it makes it difficult for U.S. artists to get the public performance royalties, if at all, from foreign airplay for their recordings.
Yeah, just off that, as Dan mentioned in his talk of the EU directive of 2014, when it's finally signed by all the countries and accepted, is a very positive sign. It excludes Britain, obviously, now because of the Brexit situation, but at least that's positive for the future as to the possibility of U.S. artists and record companies receiving that more than just the limited right that the U.S. confers upon them.
Thank you for those responses, panelists. And I want to invite a couple other people into the conversation now, simply because I noticed they're present and they are also experts and also, I think, deserve to be acknowledged. One is Liz Storm. And so, Liz, if you're interested in contributing to the discussion, either questions or comments, please feel free. And I'll extend that also to Hillel Frankel. So Hillel Frankel was one of our panelists on March 3, and I noticed that Hillel is on the line. And I would also invite you to contribute in the form of questions or comments if you wish. And I see, Liz, you are prepared.
Well, I just want to say thank you to the panelists today, as well as last week, for Hillel for joining us and leading the discussion. With Fox Rothschild, an attorney out in Minneapolis that was able to join us. I just want to recognize also and thank Howard Hertz, who's also on the line, for all of his contributions in the state of Michigan to the arts, communication, entertainment, and sports law section. He holds a lot of panels and discussions. And Elliot, thank you so much for encouraging these panels this month on the changes with regards to the Copyright Act.